Hello, everybody. This is attorney Melanie Shapiro. I am just chilling here, finishing up some work at the office, and I figured I'd hop on and see if anybody had any questions. So, thank you everybody for joining. I'm Melanie Shapiro. Soy la abogada de inmigración Melanie Shapiro. Tengo una oficina in Massachusetts. So, I'm here just to answer your questions. I'm on TikTok, YouTube, and on Instagram Live. So please drop your questions in the comments. Let me know how you are. Shoot me your name, where you're from. Do you have any questions? There's been some crazy policies that have been going down. So I just want to be here to answer any questions that you have. Right now, I'm working on sending out letters to my clients who have pending cases for adjustment of status to do their green cards in the United States. And I'm sure you all heard last Friday that USCIS announced a policy where it's really limiting adjustment of status in the United States. So, meaning that the preference is going to be for people to leave the US and do consular processing. But there are some ways to get around that. So I am just sending out these letters to my clients to explain the new policy and what the risks are of doing this from within the US still. Hi, Otto. Yes, I'm good. How are you doing? So go ahead and put your questions in the comments. Say hi. If you're joining, I'm Melanie Shapiro, I'm an immigration attorney, and I am just wrapping up my day at the office. Like I said, I'm sending out these letters to my clients about this new policy. And so I just wanted to share some of that information with you too. So basically, what's changed is that in the past, if applicants met all of the eligibility requirements to apply for adjustment of status, that was fine. If you didn't have any serious issues going on, if you didn't have any serious criminal issues, or some of the other grounds of inadmissibility, it was pretty much that this is what we're doing and it's fine. Now, USCIS is saying that adjustment of status is reserved for extraordinary circumstances. And I just want to clarify, this does not apply for if you're applying for your green card based on asylum or VAWA or U or T visa or anything, or special immigrant juvenile status. This is really limited to other types of cases like employment-based adjustment of status, family-based adjustment of status. That's what this is really focused on. And I don't want people to just start panicking about this, because there are some things that you can do to prepare. So you have to be ready for some of the questions that'll come up at the interview. And so basically at the interviews, I posted a video about this, but basically people have to be prepared for questions like, why are you doing adjustment of status instead of consular processing? Is there anything preventing you from doing consular processing? Do you have family in your home country? Or do you have any hardships? So what we are seeing now is people have to be treating this like a waiver case, that you have to prepare a packet of evidence of good moral character, of basically whatever sort of hardship you might have. And it's kind of a catch-22 for people, because a lot of these people that they're suggesting go do consular processing abroad, then these people are from countries that are part of the travel ban. So it's literally like, oh, okay, let me leave, but then I have no way to get back in. Or for people who have, say, overstayed their visas, then if they leave the country, they're subject to a 3-year or 10-year bar or permanent bar, depending on status of their particular situation. And so it's, it's a whole new ball game. This is something where USCIS has always had discretion in these cases. There's kind of a two-step of, one, do you meet the eligibility requirements, and two, do you warrant an exercise of discretion, meaning like based on your circumstances, do I want to grant your case? And so in this situation, like I was saying, if you have serious criminal issues, if you lied, if you had other issues, then that's a reason why the case might be denied previously. So please share this video with people so that we can have people join in. I'm going to hang out here with you guys until like 6. That's when I'm hoping to leave the office. So you all can come in and hang out with me while I finish up my workday. And then, let me know who you are, where you're from. Do you have any questions at all about immigration? What are your thoughts about what's going on with all of these policies? Hope you all had a good work week, have fun plans for the weekend. Para la gente que habla español, puede preguntarme las cosas en español también. So you guys are quiet. You don't have any questions? Like, speak up. It's your chance. Let me see. Cool. So go ahead and send the questions over. If you have any questions, you can put them in the comments. If you want to set up a consultation with me, you can use the link in my bio or call my office. That information's in my bio too. I think I have some consults available next week, especially if you want to know if this policy affects you. So I was talking about the new USCIS policy regarding adjustment of status if you're just joining. For the peeps joining, please say hello. Keep me company while I finish up all of this stuff. I have to do at the office before I can go home. Basically working on sending out letters to my clients about this new policy. I have a bunch of cases now. We have to decide if they want to stay in the United States and try and do consular processing, or if we're going to switch their cases, if they still want to do adjustment of status, or if we're going to switch their cases to consular processing. So I have some ideas of strategies about how we can get around this issue and explain some of the hardships. So for some of my clients who say are LGBT, for example, and they would face criminal penalties or violence or discrimination if they went to their home countries to do their consular processing, then it would be a hardship and a reason why they can't do consular processing, and they need to do the adjustment of status in the United States. Another reason would be, say, they're taking care of somebody who's sick, or there's a person in the U.S. who, say, their spouse or their parents who depend on them for financial support, things like that. So those are some of the strategies that we're working on. Also, if you do have your adjustment interview and your case is denied and you are not otherwise in a lawful status, your case is going to get sent to the immigration court where you're placed in removal proceedings, aka deportation proceedings. But that just means that you can have the judge look at your application for adjustment of status. So you basically get 2 chances. That's the way I think it's going to go. And the only downside, I'm trying to keep people away from doing their adjustments in court because there's an additional mandatory $1,500 filing fee. And so that's a lot of money for folks. And also the immigration courts are really, really slow right now. So I'm trying to get these cases done not through that way. Let's see. I'm just looking for an envelope for one more of these. All right, I will be right back. Ask the questions that you have. I'm back. Alrighty. So, trying to see. So, say hello. Where are you from? What are you up to? Do you have any questions about immigration stuff? And then also, share the video with people. So, if there are people that you think need to get some information, then I can at least try to help answer their questions while I'm finishing up with the office. And also send roses, and then also I have a fan club. If you subscribe to the fan club, you can join on here and talk to me for a few minutes, and I can answer your questions face to face. We do have in June, which is coming up, is Pride Month. So every year during Pride Month, I do offer some free 15-minute consultations for the LGBT community. So if that's something you're interested in, send us a message and you can get on the waiting list for that. So how are you guys doing? My super attorney. Oh, hello. Who are you? Oh, okay. Hello, my dear. Nice to see you. I hope you're doing well. I love it when my clients come on here. So, yeah, go ahead and share the live. If you're coming in, I'm Melanie Shapiro. I'm an immigration attorney based out of Massachusetts. I'm working on sending out some letters to clients who have pending adjustment of status cases based on the new USCIS policy, which is making it harder to do adjustment of status in the United States. So I'm finishing up the last envelope here for these letters that I'm sending out to people. So if you do have an adjustment of status case pending, adjustment of status is not dead, but you're going to have to prepare a lot more supporting documents. I think that what's going to have to be done is it's going to be more like preparing waiver cases where you have to show evidence of good moral character, ties to the community, ties to family ties in the United States, hardship. You want to make sure you have a clean criminal record, or, if you don't, then definitely consider speaking with an attorney before filing your case to weigh out what the risks might be. All right, so we finished all of those things. That's great. What are you all up to this weekend? Anything good? Let's see here. Trying to see if there are any questions coming in. All are probably commuting home from work. Okay. Yeah. So if you guys, I have a question here. Can someone apply for citizenship with a citation of $57? So thanks for the question. And it depends. What's the citation for? Is it for speeding? Is it a parking ticket? If it's something like that and it's been paid, then yeah, that's not a problem. So what you want to do is have proof of that, have a copy of the citation and a receipt proving that you paid it. Retail sales? What do you mean? If it's like theft? If it's theft, then that's a problem. So if you do have about naturalization process for citizenship, aka citizenship, you have to show 5 years of good moral character. But if there are serious crimes, then that would be a good reason that the case might be denied. So here's the thing that I'm seeing is that now with the naturalization cases, USCIS is digging into your immigration history really closely. And if you had any of these issues, they might be reassessing whether or not you should have been granted the green card in the first place. And if they believe that you were incorrectly granted the green card, then they will put you into removal proceedings. And the only one who can take away the green card is the judge. So you need to assess those issues before you apply for citizenship. So NATO saying basically that he had retail theft and paid in full. So it also really depends on the disposition of the case of were you, if it's a criminal case, were you found guilty? Were you placed into probation? The situation with crimes and immigration is that immigration considers crimes differently than what makes any sense with the criminal court. So, for example, if you have a case and you did continued without a finding, which is something that is pretty common in Massachusetts, it basically means that for a period of time, you comply with certain conditions. You might have to do a class, you might have to pay some fines. And then after that period of time, if you do what you're supposed to do, the case is considered dismissed. But for immigration purposes, this continue without a finding or quaff, that is a conviction for immigration purposes. So you have to really look closely. There's a whole sector of law we call crimmigration, which is the crossover between criminal law and immigration. And I do both of those types of law. So if you have that sort of situation, you can get in touch with me and hire me to do a criminal evaluation and see how that might impact your immigration status. And I can let you know, okay, this is considered a conviction. This is not considered a conviction. This is considered something called a crime of moral turpitude, which is just this really archaic term that immigration uses of certain types of crimes that are, like indecent exposure or things like, that are kind of show, I don't know, not great moral judgment, prostitution, things like that. So if you're soliciting, whatever, that is considered a crime involving moral turpitude. And depending on how you came in and your current status, that can make you deportable or inadmissible, meaning you won't qualify for your green card. So that, yeah, and then the other ones of cases that might be considered a misdemeanor in criminal court will be considered a felony, an aggravated felony for immigration purposes, which means that you're subject to a bar and that you are not admissible and you are deportable. So it's really important to look super closely at the criminal record and make sure that you're okay. And also it varies from state to state. There's a very complex way that immigration interprets the types of criminal statutes and the outcomes. And so it's a state-by-state analysis. I have another person who had asked, is it safe to adjust the status through my 21-year-old son, who's a U.S. citizen? I have legal entry but overstayed. And so just to go back to the citizenship for a minute, so the 5 years of good moral character, if all of these things were resolved and that was more than 5 years ago, then yes, you can go ahead and you can apply for your citizenship. Just make sure that you have a certified copy of the docket sheet, which is basically the sheet that shows all of the things that happened in the criminal court, and it's certified with the outcome of the case. Also, you want to be prepared to get the police report so that you have that, because sometimes they ask for that as a discretionary part of the case. So back to the question about the 21-year-old son who can apply for them. And again, please send the roses. You can sign up as on the fan club. It's $9.99 a month. And then just go ahead and share this out with people. I'll be hanging out here for a while until I go home and while I'm doing some other stuff at the office before I leave. So if you know somebody who needs some information, then go ahead and send it to them. So yes, your son can apply for you if they're over 21 and they're a U.S. citizen. But the problem is that you overstayed. And the issue there, especially now with this new rule from USCIS, is that if you have overstayed and you're applying for adjustment of status, that is a significant negative factor that they're looking at. So with the new USCIS rule on adjustment of status, we need to be preparing a lot of documentation to show positive factors that outweigh the negative ones. The questions that we're seeing at the interviews now are, why did you apply for adjustment of status and not do consular processing? Are there factors why you can't do consular processing in your home country? Do you have family there? Do you have any sort of hardship? So these are the types of questions we're now seeing after that policy. So you got to prepare all of the documents to support that. So you're looking at letters from friends and family. If you have a house of worship, getting a letter from the leader. If you're doing volunteer work, which you should be doing, especially in light of this new policy, then you're going to want to get proof of that. Employment history, you want to absolutely have been paying your taxes, bring your taxes with you. And if there's any criminal stuff, you need to get all those certified copies of the docket sheets. If there's hardships, they have to be documented. So if you have a sick child or you have a sick parent or someone that you're taking care of that relies on you, then you want to get proof of those conditions. Okay, so thanks for your question. Okay, so I didn't hear you about the T visa with the sexual harassment. Okay, so again, I just want to mention that I am doing some free 15-minute consultations in June for people from the LGBT community in celebration of Pride Month. So if you're from the LGBT community and you are interested in doing that, you can send a message on TikTok and I will then forward it to my team who can get you set up. I don't have the date of the consultations yet. Thank you. And Rose is asking, sorry, I didn't hear you about the T visa with the sexual harassment. I didn't talk about a T visa. So with the U visas and T visas, so U visa is for victims of violent crime and a T visa is for victims of trafficking. And if you have criminal history, well, with the T visas and the U visas, there are certain things that are automatically waived that are grounds of inadmissibility, like if you entered the country illegally or you overstayed or you worked without authorization. These things are not a problem for adjustment of status for those categories. But if there's other reasons that you have a ground of inadmissibility, like a criminal offense, then you have to apply for an additional waiver with your application for the U visa, the T visa, the VAWA. So, it depends on the outcome of the case and the circumstances. Toyson is saying, hey, I arrived in August 2021 by I-94, but received my green card on 2023 by SIV program when I came. Are you from Afghanistan? It was the SIV with Afghanistan. Because that's about the right time frame. So, yeah. Yes, you are. Okay, cool. So, for applying for citizenship, I'm not exactly sure. So you got your green card in 2023. Cool. So then for citizenship, you generally have to wait for 5 years to apply. Okay. And then for Rose says, but if you have been on sexual harassments situation, can you apply for qualify for the T visa without any police? Yeah, so I know what you're saying. So to talk a little bit about the difference between the U and T. So if you're able to do a T visa, then that's definitely an easier route to go than a U visa. A T visa, you do not need law enforcement to sign off on this. You don't even have to have reported the crime in order to apply for the T visa. With the U visa, you can't apply for the U visa until you have law enforcement fill out a form and sign it, which is certifying that you were a victim of the crime, that you have knowledge of the crime, and that you've cooperated in the investigation or prosecution of the crime, with some exceptions. And so in this situation, being a victim of sexual harassment, that's not human trafficking unless there's more information you're not providing. So for sex trafficking, you have to show that basically you did a commercial sex act because of force, fraud, or coercion. And the commercial part of it is basically you had sexual relations with a person for an exchange of anything of value. So that could be money, that could be drugs, it could be housing, and that you are in the United States because of the trafficking. So if this trafficking happened to you in the United States after you came here, it's not related at all to how you came here, that is not enough for a T visa. And there is a lot of overlap between T's and U's. So there are certainly a lot of crimes that are also, there's components of those that are also human trafficking. So if somebody is a victim of trafficking, they can apply for a T visa or a U visa. If it's not been reported to the police, they can apply for the U visa. So it just depends. And with the U visa too, you just have to prove that you have knowledge and you've cooperated with law enforcement, and this has been reported, but there doesn't have to be a conviction for you to be successful with a U visa. I've also been able to get U visas for people based on filing restraining orders, and that has been sufficient if there's a good history to support that and show that there's, an impact on the person because of that conduct. Does the petty offense exception work for citizenship? The petty offense exception is relative to the green card. It doesn't have to do with citizenship. So again, there's a discretionary component to citizenship applications. So if you had an offense within the last 5 years, then say, for example, you got your green card through marriage, you only have to wait for 3 years to then apply for your citizenship. And that 3-year period is what's considered. But if it happens like within the last 5 years, then that's going to be a negative discretionary factor. So you want to be prepared with other documents to show that you have some positive things to overcome that negative factor. Toyson says, so when will I be eligible for that, for my green card date? So I think it's the 5 years after you were admitted on SIV, though I'm not 100% sure if there's any sort of exception. I know that for people who got refugee status or asylee status, then they can apply after 4 years, so long as they have been in the United States in total for 5. And you can also, for all of these applications, you can submit your applications 90 days before the actual date. So, for example, if you are filing for your citizenship and you got it based on marriage and you have to wait for 3 years, then at 2 years and 9 months is when you can submit your application for naturalization. Let's see. How about green card applied May 25 under Afghan SIV? Yeah, I don't know the exact time frame. I'm pretty sure that the SIVs are exempt from the new adjustment of status policy, but this is also super new, so we're all just keeping an eye on things and seeing how it goes. This policy is very much illegal the way it was implemented, and I expect that we're going to be seeing lawsuits challenging this policy. I plan on filing some lawsuits myself about some of the other policies, such as the asylum ban and also the immigrant visa ban from certain countries. A number of attorneys are filing what's called a writ of mandamus application, writ of mandamus in federal district court, and this is basically saying that the government has a duty to act on this in this situation, and because they have not acted, then this violates the Administrative Procedures Act and that a writ of mandamus should be issued. And that basically, mandamus is mandating, so it's making the government do its job. So we have to just monitor this. Immigration attorney, blah, blah, blah. Oh, that's the AI thing. Yeah, thank you, Hamid. See. Okay, so if you have any questions, go ahead and drop them into the comments, send some roses, share this video with everybody. I am planning to stay on until about 6 o'clock. So while I am doing this video with all of you, I am also trying to get some things done at the office. I sent out a bunch of letters to my clients who have pending applications for adjustment of status to let them know about the new policy and strategies that we can do to try and overcome some of the issues there and some of the risks that are associated with continuing with adjustment of status and not applying for consular processing. So if you do decide that you want to do consular processing, you have to let USCIS know that you're changing from the adjustment of status to consular processing, which means that you have to then leave the United States, go back to your home country, and then go for an interview there. So it can take some time for that to get situated. And I mentioned before, one of the things that's kind of ridiculous is asking people to leave the United States when they're on the list of the 75 banned countries. So the 75 country ban is for immigrant visas. And if you leave and you're trying to get your green card, doing it through consular processing, that's considered an immigrant visa. And if you're on the country ban list, that means that you're not going to be allowed to come back in. I'm also seeing some issues too with some of my clients now who have applied for family members who are in countries where there's the ban from Ebola. And so, for example, I've got some kids that one of my asylum seekers who won his case applied for them to come to the United States. They're all ready to go. They have their foils and their passport, but they were denied getting onto a plane because of that ban. So, there's that going on. Then the 75 country ban for immigrant visas, and also the asylum ban, which has been partially lifted except for 39 particular countries. So there's a lot going on. All of these things are really unconstitutional. And I mean, the Ebola thing, I understand from a safety perspective, but the others are crazy. And so I'm filing some mandamus lawsuits in federal government, suing the government to make them take action on these cases. So let's see. So if you do continue with your adjustment of status with USCIS and you get denied, if you don't have another lawful status, then that means that your case is getting referred to the court, the immigration court. You're going to be placed into removal proceedings, which means that you're going to be placed in proceedings to deport you from the United States. But you get another chance before the judge to present your I-45, your adjustment of status application. And as for the time being, this policy is with USCIS, which is not related to the court. So that policy does not then continue to USCIS. The downside, though, about having to do it in the court is obviously stressful. It will take a long time because the courts are super backlogged. So people aren't getting dates here until like 2030. And then also financially, there's a mandatory additional filing fee of about $1,500 that Trump imposed a while back. And so if you've lost the chance with USCIS, that means you then have to pay the additional money for the adjustment in court. Ricky says, my son is in the Army, but not 21. Can we apply for deferred action? That's a good question. So there's something called military parole in place. And I am just actually now going to Google that and look at the instructions on USCIS. Because I'm not sure if that also applies to parents who it says for parents. I would think that it would be okay because this is a different situation as opposed to the I see what you're saying. This is a different situation opposed to, say, the applying for a I-130. There are some benefits of being a family member of someone in the military, and also if you're in the military and you get your green card, then you can apply for your naturalization basically right away. Rookie, you overstayed your visa. Got it. So with the military parole in place, that also paroles you for a period generally of up to 2 years of deferred action. So that at least will help. And it's good you already have a lawful entry. So for that, actually believe that for the military parole in place, then that makes it easier then to apply for your green card. And let's see, because you're only eligible to do that if you don't already have lawful status. And the good thing about this too is it's not just for people actively in the military, but veterans as well can apply for military parole in place for their family members. And that's for sons and daughters, for parents, and for spouses. Let me see. So I have a question here from someone, I'm assuming you're from Afghanistan, maybe an Arabic speaking country, about a U visa. What about it? Then I have someone says, ma'am, I just received my I-130 file by USCIS for my wife. She is from Nepal and I'm a US citizen. What's new? What's new? Whew, go look at my other videos. There's a video I did about the new policy with USCIS about adjustment of status. So again, like, share, whatever in my video, follow me on TikTok. If you're interested in a consultation, use the link in my bio to schedule one or send us a message and we'll reach out to you. For the LGBT community, we'll be doing a free 15-minute consultations one day during June. I don't have the date yet. The spots are limited, so you can let us know you want to do it, and then we could put you on the wait list. The process for the U visa. So for the U visa, there's a list of qualifying crimes. If you are a victim of any of those qualifying crimes, that's one element of it. The other thing is you have to show that you are someone who has knowledge of the crime, that you are cooperating with law enforcement or have cooperated with law enforcement. So that means that the crime does need to be reported, and you need, in order to move forward with it, you have to have law enforcement sign a form certifying that you are a victim of the crime and that you have been cooperative. There's exceptions to the cooperation if, because of the nature of the crime, the trauma you suffered, PTSD or whatever, that you are unable to participate in that process. You have to show that you've suffered substantial mental or physical injury because of the crime, and that otherwise you would qualify for this form of relief, and you don't have really significant criminal issues or other issues that would disqualify you. So the process is you go and get the law enforcement certificate first. If you don't do that, you can't pass go, you can't do anything else. And then if you do get that, then the next step is to file for the form I-918, which is for the U visa. And then you also need to file the form I-192 if you have any grounds of inadmissibility, apart from just entering US illegally and overstaying or working without authorization. Those are automatically waived. So you file the I-918, the I-192, and then you also then you file that and you get a receipt notice. You wait for a couple of years. If it looks good, then the USCIS will send you what's called a bona fide determination letter, which gives you deferred action so that you can't be deported during that time period, and you can also get a work permit. The time, so there's a limit on the number of these available. There's a limit of 4,000 every year, and there's a serious backlog. So we're looking at like 10, 15, 20 years. The new memo. So the new memo, I talked about that at length before, but basically USCIS has issued a new policy last Friday about adjustment of status, that it's being reserved for extraordinary situations, and really increasing the requirements if you do want to apply for adjustment of status in the US. So that means that you have to really beef up your case. There's 4 new questions that are being asked, essentially. Why are you applying for adjustment of status and not consular processing? Are there any factors that are preventing you from doing consular processing? Do you have family in your home country? Are there any hardships that you have that would explain why you're doing adjustment of status? So those are the 4 new questions that we're hearing about from the interviews taking place at USCIS for adjustment of status. And then for the hardship and so forth, I'm seeing this as we're going to have to prep these as a big packet of evidence. So we're looking at showing good moral character. So, that you've been paying your taxes, that you don't have a criminal history, you have family ties in the US, you have ties to the community, you're doing good things here, you're not falling on public benefits. And then for the hardship, if you say you're ill, someone in your family is, or you're taking care of everybody, you want to have some proof of that. So those are the types of things that you're going to have to be prepared for. And then worst case scenario, you get denied with USCIS, you get put into removal proceedings in the immigration court, and the immigration judge then can hear your adjustment of status application. But there's an additional mandatory $1,500 filing fee for the court. Thank you for your question. And I did write a blog about this. It's on my website. The link is in the bio. Also check out the other videos that I did. And then Larissa, hello, I'm changing of status from R2 to H1B. Would the new memo thing affect me a lot? No. The new memo applies to adjustment of status. It doesn't apply to non-immigrant visas. So, you should be fine. And in terms of that, timing, you need to file the change of status and make sure that H1B is filed and approved and all of that stuff. Then, do I need to worry about the new policy or just pause that process to forget what you were doing? So that's kind of up to you about, there's risks to continuing with adjustment of status. If you don't have any of these extraordinary circumstances you can show, then maybe you want to consider doing consular processing. But if you're from a country that's on the travel ban list, you don't want to do that. If you overstayed in leaving the United States, then would then make you subject to a 10-year bar, then you don't want to do that. Those can be situations where you can explain, this is a reason why I cannot do consular processing. And also, I know people are panicking, but we have to wait this out a little bit because there are going to be lawsuits that are challenging this. And there are going to be lawsuits that are challenging this policy. I certainly will be filing some mandamus lawsuits, which is just suing the federal government to make it do its job, and challenges under the Administrative Procedures Act. So don't panic about this. Be prepared. and get together those evidentiary packets with all of these additional documents, and see if there's any alternative types of cases that you might be eligible for as a backup, like U visa, asylum, whatever it may be. So the best thing to do is consult with an immigration attorney. If you're interested in consulting with me, then you can use the link in my bio to reach out and try and schedule a consultation, or send us a message and I'll try and send those messages to my admin next week and get you set up. Let me see. Alrighty. Okay, so I have another question from Olenka. Hi. If I got all the required forms before the memo, can I still do adjustment of status I entered as a tourist, or is it risk? So the thing that kind of sucks about the new memo is that it applies to pending applications too, not in the decision about whether there are extraordinary circumstances is at the time of adjudication, not at the time of filing. So unfortunately, this does apply to all of the pending adjustment of status applications too. So if you entered as a tourist, there's a risk, absolutely, that, like I said, you can get put into immigration court proceedings, into removal proceedings if you've overstayed, if you don't have any other lawful status. Then you then have the chance to present it to the judge. So that's up to you. And as I mentioned before, getting your case heard in the immigration court is going to take a very long time. Here in Boston, cases are being scheduled out to 2030. Now, those are mostly for bigger individual hearings like asylum cases, so maybe it'll be a little bit quicker for adjustment of status. But still, you have to consider that. And again, if you go back to your country and it's on the 75 travel ban countries, then you don't want to do this. One caveat I do want to mention too is that for the marriage petition, so if you filed an I-130 and that's approved and that's how you're doing your adjustment of status, what you can do to kind of get around the travel ban situation is that you can go back to your home country and then apply for what's called a K3, which is a K1 is a fiancé visa, and the K3 is for basically that, but for people who are already married. And the Ks are considered non-immigrant visas, so you should be able to get around the travel ban because the travel ban is only for immigrant visas, which is from the I-130s. Can I travel with my new? Let me see. I just want to make sure I didn't miss anyone. Okay, I have a question. Can I travel with my new green card under SIJS to my home country? I mean, it depends. Classic lawyer answer, right? So for this situation, it depends, right? Depends. What country are you from? And also, do you have any criminal history? Do you have any other issues, any fraud, any issues at all? There's always a risk when you travel outside of the US and come back on a green card, because every time you show up to the airport, you're asking to be admitted into the United States. So a lot of people, even if you have green cards, are getting pulled into secondary inspection. And USCIS and ICE, they're looking really closely into the basis of how you got your green card. And if there's something amiss, then they are going to put you into removal proceedings. You can be detained. My preference for my clients is that they don't travel until they have their citizenship. So it's a risk if you don't have any of those factors that I'm talking about, of like criminal history and so forth, then you might be okay. But it's a risk and you have to decide whether you want to do it. Savage, hi. What if I'm married with kids and my wife filed adjustment of status for me? Will the memo affect me a lot? It's going to affect everybody in this. So you, yes, and that's a very good point. So with the immigrant visa ban, the travel ban of these 75 countries, that also applies to immigrant visas in the US. And so you're not going to get a decision on this. This is a case where I'm filing mandamus petitions in federal court. It's a lawsuit to force the government to make a decision about your case. So what probably is going to happen is you'll have your interview and then you won't receive a decision. But again, because of the new memo, you have to show why you cannot do consular processing. And you have to show you have hardships, good moral character, all of that stuff. And if your adjustment is sent to the court, you have to see the judge. And that's not I'm not super concerned about that, honestly. As long as you don't have any other serious issues going on, that should be fine. Because this policy pertains to USCIS. It does not apply to the immigration court. They're totally separate parts of the Department of. So the USCIS is part of the Department of Homeland Security, and the Immigration Court is the Department of Justice. These are two different agencies with two different sets of policies. Savage, yeah. So yeah, you should be fine. So if you don't have any crazy criminal history or anything, then you can go to the immigration court. The other thing is there's a mandatory $1,500 additional fee. So just be prepared for that. And when you go for your interview, just make sure you have a packet of documents to support why you might have hardship. For this situation, I was saying before, one strategy is that if you're from a travel banned country and you have to go and do consular processing, that's crazy, because then you're not going to be let back in. So how are you supposed to do that? So I think that you should be using that argument as part of your strategy of explaining why you cannot do consular processing. And if there's something in your home country where it would be dangerous for you to return, then you should bring that up as well. All right. Well, thank you for your question. Thank you, everybody, for joining in on the live. I'm glad that you all had so many good questions today. If you're interested in doing a consultation, my name is Melanie Shapiro. I'm an immigration attorney based in Massachusetts. And you can send a message to schedule. You can also use the link in the bio to schedule. The information in my office is there, so you can call next week. For the LGBT community, to celebrate Pride Month, as I do every year, I'm doing free 15-minute consultations. So if you're part of the LGBT community and you want to take advantage of that, you can go ahead and send a message to save your spot for that day. There's just a limited number of spots. I think it probably do 10 people. So sign up for that in advance and save your spot. All right. Thank you, everybody, for joining. I hope you have a great weekend.